Welcome back to the Deep Dive. Today we are taking on a vast and, well, a really complex subject. It's one that doesn't just define laws, but actually defines latitude and longitude, the constitutional geography of India.
It's an essential dive, really. If you want to understand India's political structure, this is fundamental. We often talk about federalism in terms of, powers and rights.
Sure.
But today we're looking at the actual blueprint of the nation itself. The map of India, as defined by its foundational document, it's not some static piece of parchment.
It's a living document.
It is. It's a living, breathing legal definition, and it's capable of dramatic, deliberate, and sometimes almost instantaneous change.
So our mission today is to give you a really structured understanding of how the Indian Constitution approaches its own physical territory. We're going to look at the provisions for defining, acquiring, ceding, and maybe most importantly, reorganizing states.
And we'll uncover some surprising flexibility, won't we? We'll analyze some constitutional anomalies like the associate state of Sikkim.
Which is a fascinating story.
It is. And we'll examine the almost unrestrained power Parliament holds to just redraw the internal map.
Okay, so to do that, we have to start at the very beginning, Article 1.
We have to. The name of the political structure prescribed by the Constitution is a federal union. And its name, as stated right there in Article 1, Clause 1, is India or Bharat.
And what does that union consist of today?
Currently, the union is made up of 28 states. Andhra Pradesh, Uttar Pradesh, Maharashtra, Tamil Nadu. These are the constituent units that form the core of the federal system.
Okay.
But here is the immediate crucial distinction that really sets the stage for our entire discussion.
Okay, let's unpack this distinction then between the political union and the broader territory. Why does the Constitution even draw a line between those two terms?
Well, the difference really lies between political membership and, let's say, mere sovereign control. The term Union of India is quite restrictive. It refers only to the states, those 28 members that share a defined distribution of legislative and executive powers with the central government. They are the federal partners.
So when we talk about India in a political sense, we're often just talking about those 28 states. But the physical country, the actual landmass over which India has supreme authority, that's bigger.
Absolutely. The term Territory of India is the broader, more expansive expression. It covers the entire geographical area over which the sovereignty of India extends for the time being.
So if the states are the core, what else falls under that massive umbrella of Territory of India? We're looking for the total footprint of India's sovereignty, right?
Exactly. And the Constitution lays out 3 distinct classes of territory that make up the whole of India. That's in Article 1, Clause 3.
And what are those 3 classes?
Okay, so first, you have the states, the members of the Union we just talked about. Second, you have the Union territories, or UTs. Now, these are centrally administered areas. They don't have the same constitutional status as states, and they're not full members of the federal system in that power-sharing sense. They're generally governed directly by the center.
And the third category? This one seems to speak to India's ability to change its physical size over time.
That's the one. The third class is defined as such other territories as may be acquired by India. This is the constitutional mechanism that gives Parliament the explicit foresight to expand the nation's physical boundaries.
Through legal means, I assume.
Yes, through diplomacy, treaty, cession, or even theoretically, conquest.
That concept of acquired territory suggests a kind of limbo state, doesn't it?
Right.
If India acquires a new piece of land tomorrow, does it immediately become a state or a UT?
Not necessarily, no. It remains an acquired territory until Parliament decides its ultimate constitutional fate. In the meantime, it's administered directly by the government of India, and Parliament has the power under Article 246 to make laws for its governance.
So sovereignty is immediate, but political integration might take years.
That's it exactly. The key is that the political integration is a separate, deliberate step.
And the history of the French settlements offers the perfect illustration of this constitutional limbo.
It really does. We're talking about Pondicherry, Karakal, Mahe, and Yanam. These were territories governed by the French for centuries.
Right.
They were ceded to India through a de facto transfer in 1954. But crucially, they were administered as an acquired territory for 8 long years, right up until December 1962.
8 years. Why the gap between getting physical control and full constitutional integration?
It all came down to international law. The transfer, while politically complete on the ground, needed legal finality. The Treaty of Cession itself had not yet been formally ratified by the French Parliament.
So the paperwork wasn't done.
In a manner of speaking, yes. Once that ratification was secured in 1962, Parliament acted swiftly.
So what was the legislative action in December 62?
The territory of the former French settlements was officially constituted as the Union Territory of Pondicherry, which we now know as Puducherry. It moved out of the generic acquired territory status and became a defined, centrally administered political unit.
So it shows the whole journey, from general sovereignty to structured political integration.
Precisely.
That gives us the foundational geography. States forming the core union, and then UTs and acquired territories extending the domain of India's sovereignty. And as we transition, it's clear that the UT status itself is, well, it's not permanent either.
Exactly. That acquired territory status is temporary. But even the status of a union territory is constantly evolving. It reflects major administrative, political, and sometimes, frankly, volatile changes in the country. And here's where it gets really interesting: the constant evolution of these administrative units.
The map of the Union territories is a truly kinetic object, isn't it? It's always being redrawn, merged, or elevated. Since 1987, the number has shifted dramatically, and today we're at 8 Union territories.
We are. We have the established ones, Delhi, the Andaman and Nicobar Islands, Lakshadweep, Puducherry, and Chandigarh. But the most recent changes, the ones from the last few years, are the most eliminating.
And that brings us directly to the Jammu and Kashmir Reorganization Act of 2019. This wasn't just a boundary change. It was a fundamental shift in the constitutional status of an entire state.
Oh, it was arguably the most significant internal remapping in decades. The act, which became effective from October 31st, 2019, reorganized the erstwhile state of J&K into 2 completely new union territories.
And the distinction between those 2 new units is crucial, isn't it? It dictates the whole level of self-governance.
It absolutely does. First, we have the Union Territory of Jammu and Kashmir. Critically, this was created with a legislature and a council of ministers.
Okay.
This means that while it is centrally administered, it retains a degree of representative legislative devolution. It gives its people a voice in local lawmaking.
And the second unit created from that.
The Union Territory of Ladakh, comprising the Kargil and Leh districts. This was created without a legislature. It's placed under the direct, unmediated control of the central government, governed by an appointed administrator.
So one with a legislature, one without.
It's a clear distinction, and it's a profound tool that Parliament uses to calibrate the level of central control.
And at the same time, we also saw consolidation happening, sort of the inverse process of splitting.
Correct. You had these 2 small, separate administrative units on the western coast, Dadra and Nagar Haveli, and Daman and Diu.
Right.
By the end of 2019, Parliament passed an act to merge them into a single union territory, which happened on January 26, 2020. This was purely an exercise in administrative simplification and efficiency. It shows Parliament's power to consolidate just as easily as it separates.
This all confirms that not all UTs are created equal. Some are fully centrally run, but Parliament has developed mechanisms, often through Article 239A, to grant legislative status, pulling them a bit closer to the federal structure.
Puducherry was the initial template for this, wasn't it? It was granted a legislature back in 1962.
And then there's Delhi, the National Capital Territory. It's a constitutional creature entirely unto itself.
Absolutely unique.
The 1992 amendment that brought in Articles 239AA and 239AB renamed Delhi and provided for an elected legislature and a council of ministers. The idea, I suppose, was to balance the need for local democracy with the overriding national necessity of a centrally controlled capital.
And that balance has proven incredibly difficult to maintain. The tensions between the elected chief minister and the centrally appointed lieutenant governor, the LG, have been constant. The Supreme Court has had to intervene repeatedly just to interpret the division of power.
And Parliament stepped in to, let's say, clarify that ambiguity in 2021.
They certainly did. The Government of National Capital Territory of Delhi Amendment Act 2021 sought to definitively place the appointed administrator, the LG, at the very apex of the administrative hierarchy.
Even in matters related to laws passed by the local assembly.
Especially in those matters.
So what was the specific legal mechanism they used to shift that power dynamic?
It was a very surgical definitional change. The amendment explicitly clarified that the expression government, when you see it referenced in laws passed by the Delhi Legislative Assembly, shall mean the Lieutenant Governor, LG, of the National Capital Territory of Delhi.
Wow.
This was a direct response to prior Supreme Court interpretations that had emphasized the primacy of the elected government's aid and advice to the LG.
So if the Supreme Court had been leaning towards cooperative federalism, saying the LG is mostly bound by the elected government's advice, This 2021 act from Parliament feels like a significant legal pushback, a massive centralization of power.
That's the critical tension, isn't it? It's a firm reassertion of the union's power over its capital. By legally equating government with the LG, Parliament ensures the final executive authority rests with the center. It elevates the LG from a passive constitutional head to the active, decisive executive authority. It fundamentally undercuts the functional autonomy of the elected body.
And that level of central control is so telling when you contrast it with the administration of, say, the Andaman and Nicobar Islands.
Completely different. The remaining UTs operate under the purest form of central administration. They're governed directly by the president, acting through an appointed administrator. Under Articles 239 and 240, this administrator can issue regulations for the territory's good governance. There's no local legislative body, so the center's control is complete and direct.
So we've got this clear hierarchy of political integration. You have states, the full federal partners, then you have UTs with legislatures which have some devolved power, all the way down to the purely centrally run UTs.
That's the spectrum.
Okay, now let's look at how the Constitution adapted, or was forced to adapt, to absorb territories through intense political negotiations.
What's fascinating here is that the Constitution had to literally invent a category that didn't exist in 1949 to facilitate a crucial political integration. And this brings us to the dramatic developments surrounding Sikkim.
The story of Sikkim is a real constitutional detective story. It has everything: a monarchy, geopolitical strategy, a referendum, and the creation of this constitutional anomaly, the associate state.
It does. Before 1947, Sikkim was an Indian state under a hereditary monarch, the Chogyal. It was subject to British paramountcy, but critically, its northern border with Tibet was already defined by the Anglo-Chinese Convention of 1890. Its strategic importance was immense.
So when British paramountcy lapsed in 1947, Sikkim technically became sovereign. But it didn't immediately merge, like thousands of other princely states. Why not?
It was its strategic location, really, and the power retained by the Chogyal. It maintained a very special status. After some initial instability, a treaty was formalized in 1950. The government of India took on full responsibility for Sikkim's defense, external affairs, and communications.
So what did that make Sikkim, legally speaking?
It officially became a protectorate of the Union of India. India guaranteed the Chogyal's autonomy in internal administration, but all external and strategic matters were controlled from Delhi. India even appointed a political officer to oversee affairs in both Sikkim and Bhutan.
So the Chogyal sovereignty was severely constrained in practice, even though it was nominally retained. But by the early 1970s, internal democratic pressure changed everything.
It did. The Sikkimese Congress, representing the majority of the population, started demanding an end to the monarchical rule and, greater democratic rights. By May 1974, the Assembly passed the Government of Sikkim Act, which drastically curtailed the Chogyal's power. It turned him into a mere constitutional figurehead.
And effective power went to the elected assembly.
Exactly. And that assembly immediately looked to Delhi, seeking to accelerate their integration with India.
Why? What was the motivation?
They passed resolutions seeking representation in India's political institutions. They believed full integration was the best path for their social and economic development. This move forced the Indian parliament to act, but cautiously.
Cautiously, because immediate full statehood might have been too politically volatile at the time?
Precisely. So Parliament invented a temporary fix, the 35th Amendment in 1974.
This amendment is a legal historian's delight, isn't it?
It really is. Parliament passed it to implement the resolution from the Sikkimese Assembly, and the result was the insertion of a new Article 2A and a completely unprecedented Schedule X into the Constitution.
Creating the associate state status. But how could they even do that? The Constitution only had room for states, UTs, and acquired territories.
And that is the core legal anomaly. The 35th Amendment effectively created a new political classification outside the original three categories. Parliament used its immense amending power under Article 368 to temporarily stretch the boundaries of the Constitution, allowing Sikkim to enter the framework without being fully admitted as a state under Article 2.
It was a constitutional halfway house. What was the most significant restriction placed on Sikkim under this strange new status?
The restrictions really underscored its limited sovereignty. While Sikkim was entitled to send 2 representatives to the Indian Parliament, one to the Lok Sabha and one to the Rajya Sabha, Their voting rights were curtailed.
How so?
They were not entitled to vote in the election of the president or vice president of India. They could participate in legislative debates, but their contribution to the federal decision-making core was restricted.
And Schedule X basically drew the line for where India's control began and ended.
Exactly. India retained control over defense, external affairs, communications, plus social welfare. The government of Sikkim retained residual power on all matters not listed in that new Schedule X. It was designed to manage the political transition while giving the Sikkimese people a taste of Indian democracy.
But the Chogyal resented his loss of power. He tried to get international intervention, which in the 1970s would have been seen as a dangerous escalation.
His actions were seen as undermining the democratic aspirations of his own people, and it provoked a decisive reaction. On April 10, 1975, the Sikkim Assembly just abolished the institution of the Chogyal altogether.
And at the same time, they made the final move.
The final, decisive move, they passed a resolution stating that Sikkim shall henceforth be a constituent unit of India enjoying a democratic and fully responsible government.
And this resolution was critical because it was immediately put to the people.
It was ratified through an overwhelming referendum. With the Chogyal gone and the popular will crystal clear, India had the political mandate it needed to complete the integration.
Which culminated in the definitive legal step, the 36th Amendment in 1975.
This was the cleanup operation. The 36th Amendment formally admitted Sikkim into the Union of India as the 22nd state. The act was even backdated to April 26, 1975, to formally complete the merger.
And the constitutional anomaly of the associate state was just erased.
Gone. Article 2A and the temporary 10th schedule were omitted from the Constitution. Sikkim was officially listed in the first schedule as a state, and special administrative provisions were inserted via Article 371F, which, among other things, protects the rights and interests of the various sections of the Sikkimese population.
So what does this entire saga, the protectorate, the temporary status, the full integration, tell us about the nature of India's constitutional geography?
It tells us that the constitutional framework is profoundly adaptable to political reality. When you're dealing with territories that have unique historical statuses, Parliament has the power, through the high bar of a constitutional amendment, to temporarily bend its own structure.
To create a transitional category.
Yes, to create a category that gets the job done before fully absorbing the territory into the federal core. It demonstrates a sophisticated, if sometimes convoluted, approach to managing national integration.
Okay, so we've seen how India deals with internal reorganization and the absorption of protectorates. Now, let's pivot to the highest constitutional hurdle of all, changing India's physical footprint when it involves ceding territory across an international border.
The constitutional stakes here are dramatically different. We're moving from internal administrative changes to defining the ultimate external sovereignty of the nation. The key event here is the 100th Amendment Act of 2015, which finally resolved the Land Boundary Agreement, or LBA, with Bangladesh.
And this was a process that took 41 years to finalize.
41 years.
So why did a border resolution take over 4 decades? We need to go back to the original Radcliffe Award of 1947, which really created this mess in the first place.
It did. That initial division, which partitioned Bengal, created a boundary that was ill-defined and just riddled with issues, including the infamous enclaves and territories held in what's called adverse possession.
So disputes arose
Immediately. This led to some partial fixes, like the Bag Award in 1950 and the Nehru-Noon Agreement of 1958.
And that Nehru-Noon Agreement immediately created a massive legal challenge in India over the transfer of a small area called the Birabari Union.
That case before the Supreme Court in 1960 became the defining moment for India's external boundary law. The Supreme Court was asked, essentially, can Parliament just pass an ordinary law to give away a piece of India, or does it require something much, much higher?
And what was the court's definitive ruling? Why wasn't Parliament's typical power under Article 3 enough?
The Supreme Court ruled definitively that Parliament's power under Article 3, the power to diminish the area of any state, only applies to internal boundary reorganization.
I see.
Article 3 is about internal management. It's about administration. It cannot be used to extinguish the sovereignty of India over its territory by ceding it to a foreign state.
So to cede even a single inch of sovereign Indian territory to a foreign power, what was constitutionally required?
It required the ultimate legislative act, a full-fledged constitutional amendment under Article 368. The Constitution's very text had to be amended to formalize the loss of territory. This high bar was set to ensure that national sovereignty can't be diminished by a simple majority vote.
And this ruling led directly to the Constitution Ninth Amendment Act, 1960. That was the initial legal attempt to implement the land swaps in the Nehru-Noon Agreement.
Yes, but because of political instability and later developments, especially the formation of Bangladesh in 1971, that 1960 act was never fully implemented for those territories. The whole matter required a comprehensive new approach.
Which came in the form of the 1974 Land Boundary Agreement and then the 2011 Protocol.
Exactly. And the 2011 Protocol, which was signed with the concurrence of the affected Indian states Assam, Meghalaya, Tripura, and West Bengal, was critical because it sought to resolve three major issues: undemarcated stretches of the border, adverse possession claims, and, of course, the exchange of enclaves.
The enclave issue was particularly complex and really a humanitarian issue.
It was. These were small pockets of land belonging to one country but completely surrounded by the other, sometimes nested multiple times. People living there faced an immense jurisdictional limbo. They were cut off from their national governments. The swap was necessary to bring clear boundaries and legal certainty to these populations.
So what were the final physical results of the swap ratified by the 100th Amendment?
The amendment formalized a balanced exchange. India transferred 111 enclaves, which was about 17,000 acres, to Bangladesh. In return, Bangladesh transferred 51 enclaves, about 7,000 acres, to India.
And it also finalized the last bit of undefined border.
It did. It legally resolved the demarcation of a final 6.1-kilometer undefined stretch.
If we connect this back to our larger theme, the land swap beautifully illustrates the constitutional barrier between internal flexibility and external rigidity.
It does. Parliament has immense, almost unchecked power over internal boundaries, which we're about to get into. But that power stops dead at the international boundary. The Constitution mandates that any act diminishing national sovereignty requires the high democratic consensus enshrined in Article 368. It's a crucial distinction in India's legal geography.
And now we arrive at the most dynamic and perhaps the most controversial aspect of India's constitutional geography, the power to redraw the internal map. This power is often shocking to external observers who are familiar with other federal models.
It is the ultimate expression of the Indian state's power over its constituent units. And to understand this, you really have to contrast it sharply with the traditional federal system.
Take the United States, for example.
The U.S. is an indestructible union of indestructible states. The national government cannot unilaterally form a new state by splitting an existing one. It can't alter a state's boundaries without the explicit consent and concurrence of that state legislature.
It's a compact.
It's a constitutional compact among equal sovereign-like entities.
And India rejected that model completely.
Completely. The framers of the Indian Constitution were very clear. The Indian Federation was not the result of a compact. The boundaries of the provinces, which were inherited from the British, were arbitrary. They were based on colonial convenience. So the makers intentionally installed a mechanism, Article 3, that empowers Parliament to alter the territory or integrity of its units without their consent.
This means India is an indestructible union of destructible states. The integrity of a state is not guaranteed by the Constitution against the will of the Union Parliament.
That is the core legal reality. The power to reorganize states resides almost entirely in Parliament, and it's carried out not by a difficult constitutional amendment, but by a simple, ordinary legislative process. A state can protest all it wants about its boundaries being altered, but it is ultimately, constitutionally powerless to resist the will of the Union Parliament.
Why was this incredibly liberal, almost unitary power seen as necessary?
The political imperative after 1947 was just overwhelming. The administrative structure they inherited was a patchwork, and there were intense, often violent demands for states to be reorganized along linguistic and cultural lines. This was a crucial democratic requirement to make governance comprehensible to local populations.
So Article 3 was the safety valve.
It was the safety valve built in to manage this inevitable reorganization later on.
Let's break down the scope of that power.
Yeah.
What exactly can Parliament do under a simple majority law of Article 3?
Parliament's powers are comprehensive and total. By law, it may: 1. Form a new state. This can be done by separating territory from an existing state, uniting two or more states, or uniting any territory to a part of a state. 2. It can increase or diminish the area of any state. 3. It can alter the boundaries of any state. And 4. It can alter the name of any state.
It is the ultimate cartographer's tool. What are the minimal procedural checks placed on this enormous power?
There are two procedural hurdles, but neither of them grants a veto power to the state. First, the bill must be introduced only on the recommendation of the president. Second, before making that recommendation, the president must refer the bill to the legislature of the affected state
But only for the limited purpose of expressing their views.
for expressing its views thereon and only within a specified time frame.
And this is where the constitutional caveat comes in that makes all the difference.
Yes. Parliament is not bound by the views of the state legislature. Even if a state passes a resolution unanimously opposing its own division, Parliament can just proceed with the law. This is the ultimate legal underpinning of India's flexible federalism.
And the constitutional genius of this flexibility is in Article 4, which ensures these massive map changes don't clog up the amendment process.
Article 4 is the efficiency clause. It states that any law made under Article 3, whether it's splitting a state, merging one, or changing its name, does not require the special formality of a constitutional amendment under Article 368.
So it's an ordinary law.
It's an ordinary law that automatically makes the necessary changes to the first and fourth schedules. This avoids the need for a two-thirds majority every time the map is redrawn. It's the reason the political map is so adaptable.
Let's turn these legislative titles into stories, starting with the intense political pressure for reorganization right after the Constitution came into effect. The linguistic demand for and their state really became the crucible for this power.
It was a moment of immense political drama and tragedy. The creation of Andhra in 1953 was a direct response to the powerful demand for a Telugu-speaking state separated from the composite Madras state. And this demand gained heartbreaking urgency with the fast unto death of Poti Sriramalu, a leading proponent of the cause.
His death, 58 days into his fast, caused mass protests and really forced the hand of the Union government.
It did. The creation of the Andhra State Act of 1953 proved that demands for linguistic alignment, if they were politically potent enough, could force Parliament to use Article 3. And this success immediately triggered similar demands all over the country.
Which led to the massive overhaul under the State's Reorganization Commission.
The SRC, set up in 1953, was tasked with recommending the reorganization of states primarily along linguistic lines. Its report led to the States Reorganization Act, 1956, which fundamentally redrew the political map of India. This single act abolished the old colonial classification of states. It created 14 states and 6 union territories, and it formed new units like Kerala.
The map continued to fracture, especially with the splitting of bilingual states in the 1960s.
A key example is the Bombay Reorganization Act, 1960. This partitioned the large bilingual state of Bombay along linguistic lines, forming the new state of Gujarat for Gujarati speakers and the state of Maharashtra for Marathi speakers. Again, this showed the power of Article 3 to create two viable states where one existed before.
And the same pattern played out in Punjab a few years later.
The Punjab Reorganization Act, 1966, was another linguistic and religious split. It partitioned the state of Punjab into the new, mostly Punjabi-speaking state of Punjab, the Hindi-speaking state of Haryana, and it created the Union Territory of Chandigarh to serve as a joint capital. A really complex surgery, all done by an ordinary law under Article 3.
We also saw the process of elevation, didn't we? Where centrally run territories were deemed ready for full statehood, especially in the Northeast.
Yes. The State of Himachal Pradesh Act, 1970, upgraded what was previously a union territory to a full state. And after that, the Northeastern Areas Reorganization Act, 1971, was a major exercise in the region, elevating Manipur, Tripura, and Meghalaya to state status, and creating the union territories of Mizoram and Arunachal Pradesh.
Both of which were later elevated to statehood themselves.
They were in the 1980s. This process shows the upward mobility inherent in the system.
The next major wave of cartography happened in the year 2000, creating the 3 so-called millennium states.
By this time, the demands were less about pure linguistics and more about governance, regional identity, the perception that these massive states were just too cumbersome to administer. So through Article 3, 3 massive internal divisions happen. Chhattisgarh was carved out of Madhya Pradesh, Uttarakhand was separated from Uttar Pradesh, and Jharkhand was created from Bihar.
All based on the idea of improving governance alignment.
That was the common thread, yes. Parliament unilaterally exercising its power.
And the most recent state creation, Telangana in 2014, was perhaps the most contentious of the modern splits.
The Andhra Pradesh Reorganization Act, 2014, separated the Telangana region to create the 29th state. The debate and the opposition in the original Andhra Pradesh Assembly were immense, yet Parliament proceeded based on the political and popular demand for the new state. The act even stipulated that Hyderabad would remain the joint capital for both states for up to 10 years, a crucial administrative provision to ensure a smooth transition. all facilitated by an ordinary law.
Finally, let's revisit the 2019 Jammu and Kashmir reorganization as the ultimate recent demonstration of this power. Not only did Parliament create new Union territories, it did so by dissolving an existing state.
The Jammu and Kashmir Reorganization Act 2019 serves as the starkest modern reminder of Article 3's reach. It confirms that Parliament's power isn't just limited to adding or altering boundaries, but extends to dissolving a state entirely and converting its territory into centrally governed Union territories.
So the integrity, the identity, the very existence of any state in India is conditional upon the will of the Union Parliament.
So long and short of it.
This inherent flexibility, which was essential for reorganization, does make you question the balance, doesn't it?
Yeah.
Does a state legislature, knowing its views are non-binding, feel genuinely respected in this process?
That is the perennial democratic question within Indian federalism. The framers valued the efficiency and necessity of national unity and integration over the regional sanctity of boundaries. They empowered the center to ensure the political structure remained manageable and responsive to democratic demands. But the consequence is that states often feel a deep sense of disenfranchisement when Parliament pushes through major changes, even necessary ones, without genuine consensus.
So the flexibility is a strength for national cohesion, but it can come at the expense of regional legislative confidence.
I think that's a very fair way to put it. Hashtag tag tag outro.
This deep dive has truly mapped the constitutional core of India. We started with the key definitions of union versus territory, navigated the complex acquisition of the French settlements, and observed the dramatic, temporary constitutional innovation required to fully absorb Sikkim.
And we analyzed the high constitutional hurdle required for ceding external territory to Bangladesh. But our central finding, really, is that India's unique federal model is defined by this structural power. India is an indestructible union precisely because the integrity of its constituent units is constitutionally flexible.
Article 3 was the necessary tool to manage the post-independence demands for reorganization, allowing the map to be constantly calibrated to better reflect democratic reality.
Exactly. The Parliament of India holds the ultimate authority to be the cartographer of the nation, constantly balancing administrative efficiency, political aspiration, and national sovereignty.
It's an immense power.
It is. And to leave you with a final thought built on everything we've discussed, we've seen states created, we've seen them elevated from UT status, and most recently, we've seen a state dissolved into UTs. Considering the immense, unrestrained power Parliament holds under Article 3, a power that requires only a simple majority to fundamentally reshape the political map, this raises an important question for you, the listener. When is this unchecked power a necessary tool for ensuring better governance and democratic alignment, and when does it become a potential threat to regional identity, allowing central politics to override legitimate local autonomy? As the demands for new states based on cultural identity or regional neglect continue to rise, what fundamental changes might Parliament enact in the coming decades using this simple majority power, and what limits, if any, should constrain this ultimate power of the mapmaker? You decide where that balance lies.